Hello viewers, this is our Nisha Prasanla. In today's video, we're going to see one of the important doctrines in CPC, that is res sub judice. This res sub judice can be covered under few parts for our better understanding. Shall we see what are those parts? First of all, the introduction, then explanation, purpose, conditions to be fulfilled regarding this doctrine, then an important example, then landmark case. Finally, what is the next stage? When we understand this next stage, then only we can clearly understand about this topic. Let's see the introduction part. Here, this res sub judice comes under Civil Procedure Code. I have already mentioned that. Section 10 of the CPC deals with this doctrine. This doctrine is also known as stay of suit. Do you have any doubt regarding why this is called as stay of suit? If you have such doubt, the next slide will be answer for that. Here, this is explanation part. Okay, shall we see the what is the explanation for the res sub judice? Res sub judice is nothing but a matter is already being considered by a court, so no other court should hear or decide on the same issue between the same parties at the same time. Okay, when we saw the explanation part, we could get somewhat ideas why the legislative makers brought this doctrine under CPC. These are the main purposes why the legislative makers brought this doctrine. Okay, shall we see what are those purposes? First one is to avoid multiplicity of litigation, then prevent conflicting decisions, then ensure judicial discipline. Now, conditions. It is also known as essentials. There must be two suits filed before different courts but in same jurisdiction. Then the matter and issue in both suits must be directly and substantially the same. In nutshell, it has to be the same case. Then the third condition is that the suits must be between the same parties or their representatives. When I stated that the terms say same, you could understand what I mean by. Now, the fourth condition is the previously instituted suit must be pending in a court competent to grant the relief sought. This is the most important condition because whenever the suit has been filed before the court, but the court had no jurisdiction at the time, this doctrine can't be applicable. Okay, then the final condition is that the second suit not be dismissed, rather that second case which has been filed before the another court has to be in stay. Now we may have the question why that second suit has not been dismissed, rather it has to be in stay. We can get the answer for this question in our last slide. Now we're going to see the example part. Here this example is between the two parties named A and B. A files a suit against B in court Y for recovery of money or breach of contract. Here B again files a suit against A. Here they are same parties. The issue is also directly and substantially very same. But B files the case in court Y. Now court Y cannot dismiss the case and cannot handle the case further. It has to keep this case in stay. Case law. This is the landmark case law for this doctrine. Indian Bank versus Maharashtra State Corporation Marketing Federation. In this case, the court clearly held that Section 10 is the mandatory one, rather, it is not a discretionary one. If you want to know about the facts or get the facts regarding this case, you can send me the yes in the comment box. This suit is answer for the question that why the second suit has not been dismissed, rather it has to be stayed, because if there is any issue in the first suit which has the same nature, at the time the second court get the jurisdiction and can decide the issues. Otherwise, if there is no issue is arising out of the suit which has been filed in the previous court, at the time the second court will dismiss that case. That is known as res judicata. We can see what is res judicata in our next slide. Okay, if you would like to watch this video and if you think this video is so useful to you, don't forget to like, share and subscribe. Thank you.